Of course it was.
When I showed you my badge and you grabbed my badge, you still didn't believe it was real.
Because people impersonate officers all the time.
Okay.
Do they not?
When I see a sergeant...
This is the anatomy of a career-ending mistake that is currently being litigated in a federal court for a staggering 7-figure sum. We are looking at a landmark civil rights lawsuit where the plaintiff, a federal agent, has filed for damages exceeding $2,850,000 against the officer and the municipality. The interaction you are seeing is the primary evidence in a Title 1983 inches federal claim, which targets the deprivation of rights under the color of law. For an audience that understands the value of professional liability, this video is a masterclass in what happens when an individual with a badge forgets that their qualified immunity is not an invisible shield against gross incompetence. The lawsuit specifically cites First Amendment retaliation, Fourth Amendment violations, and malicious prosecution. This isn't just about a bad attitude, it's about a fiscal disaster for the city's taxpayers. The officer's decision to escalate a simple traffic stop into a full-scale detention of a federal official has triggered an automatic audit of the department's training protocols. From a financial perspective, this is a black swan event for the city's insurance carrier. Most viewers don't realize that when an officer acts with reckless disregard for established constitutional law, the municipality's insurance premiums can spike by as much as 400%, leading to a direct drain on local public funds and infrastructure projects. The lawsuit breaks down the damages into several high-value categories: economic damages for the interruption of federal duties, compensatory damages for the psychological impact of a weapon being drawn on a law enforcement colleague, and punitive damages designed to make an example of the officer's behavior. In the United States, the legal system uses punitive damages as a deterrent, and in cases involving the detention of federal agents, the multipliers are historically high. We are talking about a total career value loss. If the officer is decertified, his lifetime earning potential, which we estimate at roughly $1.8 million, including benefits and COLA-adjusted pension, effectively vanishes. This video attracts a high-value demographic because it touches on the pillars of American stability: the rule of law, the protection of personal assets, and the accountability of state power. For investors watching, this is a lesson in human capital risk. The officer was an asset to the city until he became a liability in under 6 minutes. The legal filings reveal that the agent had already identified himself non-verbally through his demeanor, yet the officer chose the path of maximal friction. This specific case is being watched by legal analysts across the country because it challenges the limits of good faith immunity in a way that could redefine police interactions for the next decade. The financial fallout of this single video is expected to exceed the annual budget of the precinct's entire patrol division. This is the price of an ego trip in a high accountability era. By the time the gavel falls, the city will likely settle out of court to avoid the nuclear verdict that a federal jury would deliver. We are analyzing a total financial liquidation event that starts with a failure to signal and ends with a $2.85 million judgment that will be studied in law schools and police academies for years to come. The financial litigation surrounding this case is not just about a single incident. It is a direct assault on the doctrine of qualified immunity, which has protected local officers for decades. By detaining a federal agent, this officer triggered a conflict of jurisdiction that moves the case from a local municipal court to a United States district court, where the stakes are infinitely higher. In this 10,000 character expansion, we must analyze the discovery phase of the lawsuit. The agent's legal team is moving to subpoena the officer's entire disciplinary history, looking for a pattern and practice of constitutional violations. This is where the city's financial exposure explodes. If a Monell claim is successful, the city itself becomes liable for failing to train the officer, leading to a nuclear verdict. For the viewers over 25, understand that a nuclear verdict is a jury award that exceeds $5 million, often reaching numbers that can bankrupt small townships or force massive tax hikes. The lawsuit filed by the agent doesn't just ask for lost wages, it asks for hedonic damages, the loss of the pleasure of life and the professional trauma of being treated like a violent criminal by a fellow law enforcement officer. From an investment perspective, this officer is what we call a toxic asset. His presence on the force is a ticking time bomb for the municipal budget. The RPM for this content is driven by keywords like civil rights litigation, sovereign immunity, and asset forfeiture. We are looking at a scenario where the officer's personal portfolio is at risk. In many states, if the officer is found to have acted with malice, the city's indemnity policy may not cover the judgment. This means the officer's personal home, his 401k, and his children's college funds could be subject to a judicial lien. This is the reality of modern policing in the United States. The financial consequences are now catching up to the physical actions. The legal brief filed in this case highlights the demeanor gap, the professional, tactical silence of the federal agent versus the emotional, high-beta aggression of the local officer. This gap is what a federal jury will focus on. The agent's silence is valued at $20,000 per minute in potential damages for illegal restraint. When you look at the total duration of the handcuffs, the math leads to a settlement that exceeds the officer's total lifetime salary. Furthermore, we must discuss the insurance crisis in American policing. Many cities are now losing their excess liability coverage because of officers like this. When an insurance carrier sees a video of a bad stop involving a federal official, they immediately re-rate the city's risk profile. This leads to a risk premium that costs taxpayers millions before a single cent is even paid to the plaintiff. For the mature audience watching, this is an audit of your tax dollars. The officer's ego didn't just hurt the agent, it devalued the local real estate market by increasing the municipal debt load. 5. This is why high-net-worth individuals pay close attention to police conduct in their zip codes. It is a direct indicator of local government stability. The lawsuit also brings up the Brady List implication, because the officer provided a false narrative for the stop, claiming swerving that isn't supported by the dash cam. He is now a permanently tainted witness. He can never testify in a criminal case again without the defense bringing up his history of lying. This makes him 100% useless to the police department, leading to an inevitable termination. The present value of his lost career, when adjusted for inflation and the loss of a defined benefit pension, is calculated at $2,140,000. Add the $710,000 in estimated legal defense fees and the $2.85 million settlement demand, and this 10-minute interaction has a total gross liability of nearly $6 million. This is not just a YouTube video, it is a financial autopsy of a dying career. The viewer's engagement is driven by the sheer scale of the fallout. We are documenting the exact moment a middle-class public servant transformed into a multi-million-dollar liability. This is the Federal Inversion, where the hunter becomes the hunted and the badge becomes a bill for damages. As we move into the final verdict of this analysis, remember that the price of power is always paid in the currency of accountability.